Hello, everyone, and welcome to the August Career Advice Series webinar, Career Paths to the Bench. As you know, the Career Advice Series is produced by the ABA Legal Career Central, a service that offers really a robust source of career development resources and serves to connect legal professionals across all disciplines and career stages with employers offering career opportunities. As you know, our program today is Career Paths to the Bench. This program is being co-sponsored by the Judicial Division of the American Bar Association. I am Chris Browning. I'm a litigator and an appellate attorney with Troutman Sanders in Raleigh, North Carolina. I have to tell you that I am, even though I am an active member of the ABA's Judicial Division, I am not a judge. The Judicial Division, as folks might not necessarily know, has a number of attorneys who are actively involved in that organization. My background, as I said, is as an appellate attorney and as a trial attorney. I had the pleasure of serving for 7 years in the North Carolina Department of Justice, and am truly privileged to be moderating this discussion with the 3 judges that you'll be hearing from. Our panel, let me introduce them. The Honorable Heather Welch is a judge in on the Superior Court in Marion, Indiana. Her cases and matters involve complex civil litigation. Prior to coming on the bench, Judge Welch worked as a prosecutor and as a deputy attorney general. Our next panelist is Judge Andre Davis, who is a senior circuit judge on the 4th Circuit. Prior to joining the 4th Circuit, Judge Davis served as a federal district court judge in Maryland. Prior to that, he served on many courts throughout the Maryland state court system. Judge Davis also worked prior to that in the Civil Rights Division of the United States Department of Justice. Our third panelist is Judge Barbara Lynn. Judge Lynn is the Chief Judge of the Northern District of Texas and is the first female to serve as a Chief Judge in our federal courts in Texas. Judge Lynn is well regarded in terms of her contributions and leadership to the profession, has been very involved in the American Bar Association. Prior to joining the bench, she was on the executive committee of a very well-known firm and well-respected firm in Texas. Essentially, we have 3 great panelists who have a tremendous amount of practical advice to offer about folks who have an interest in pursuing a career in the judiciary. And with that, let me turn it over to our panel. If I could first of all ask you to address from a 50,000-foot level the advice and guidance that you would give to people that might be interested in pursuing a career in the judiciary.
Well, Chris, this is Judge Lynn. I'll start, just since I was the last one you mentioned, I'll be the last in, first out. I would suggest to everyone that it certainly is a worthy aspiration and career goal to try to pursue a career in the judiciary, but as we all discussed and are preparing for today, part of it involves lightning striking, and there is an element to it that one really cannot prepare for. The best way to prepare for a career in the judiciary is to be a well-respected professional in whatever area of practice you are in. The different systems that we either now represent or represented in past careers certainly demonstrate the different pathways to a career in the judiciary, appointment versus election, bipartisan versus partisan election, all of those things, when you get down into the details, necessitate a different career approach. But I think all of us would share the view that doing your work at the highest level and engaging in a professional work that allows you to demonstrate that, not just in representing clients, but in engaging in bar work so that people know that you are the kind of person that would make a good and competent and trustworthy judge is, in the big picture, the best way to get started.
And Judge Davis?
Well, I certainly agree with the wise words of my dear friend Judge Lynn, and would emphasize the lightning strike character for most of us who've ascended to the bench. I would say certainly to younger, less experienced attorneys that it's not a bad idea to have in the back of your mind the prospect of assuming the bench someday, but I certainly would encourage you in your early career to leave it in the back of your mind. What I mean by that is your focus, your concentration, your efforts at achieving the highest excellence in your professional performance is to become the best lawyer you can become. If you're thinking about becoming a judge, I suspect that to a greater or lesser extent, you spend a lot of your time preparing for court, going to court, and the writing that's entailed either in a criminal or civil practice to prepare when you are in court. And that certainly should be the focus of your endeavors. At the same time, as Judge Lynn alluded to, of course, it's also important to be a fully formed professional. And what I mean by that, of course, is to participate in bar association activities at the local, state, and federal level, to occupy offices in those associations, not simply membership, and to assume leadership positions within those organizations as a way of the kind of networking and bridge building that you will need when that great day comes when you have an opportunity either to apply for, run for, or seek appointment to a judicial position. And then finally, I would simply emphasize the importance of a broader involvement in your community. It's not going to be enough, in my experience, simply to be a great lawyer and a great member of the bar in terms of professional activities. People who appoint judges, people who elect judges are also going to want to know in what ways that you give back to your broader community. And so service on nonprofit boards, volunteer activities in the broader community, and that kind of involvement will go a long way when you are 10 or 12 or 15 or 18 years down the road of your career, and people are looking at the record you've compiled to see what kind of judge you are likely to be. A person who's connected to other people, who give of themselves, and who have the kinds of character traits that I think all of us want in judges at whatever level.
And Judge Welch?
Well, I would absolutely agree with Judge Lynn and Judge Davis, and I'm going to expand on a couple of things that they talked about. I think the number one thing is you can never be professional and civil enough in your practice in what you do as a lawyer and what you do in your communities, because people really do take notice of that. And I think for good judges, it's really important that we have lawyers that are very professional and kind of rise above some of the challenges that you have in practicing law and appearing in front of a court. Judge Davis hit on it, but I do really believe that volunteering your community, doing work is important. You have to decide what that is, whether you're going to serve on some kind of nonprofit board or volunteer if you have kids at your school. But I think becoming a judge, no matter what the system that you become a judge under, is a very competitive process. I think most judges will say, I never thought I would be a judge. It's not anything when I was in my younger part of my career I even thought about. But sometimes those opportunities present themselves, and sometimes they work out and other times they don't. And I think you have to prepare for that, and you can do those things by being involved in your community. You can volunteer at your church, you know, being involved in bar associations. And I thought Judge Davis really hit on a really important part. It's not just about being there, but you actually have to do something and show that you can be a leader and that you've accomplished something that maybe betters our profession. I think once you get to a point in your career that you're going to seriously consider being on the bench, I frequently have lawyers in my community reach out to me and say, well, I don't really know what it requires. And so that's when it will require you to know, well, what kind of system or what process does the law require you to go through to be considered? And that is really important because you need to network with people to find out, well, you know what it is on paper, but really what you have to do might be quite different. And you should, I would encourage you to understand that before you say, oh, I want to do this. Because once you figure that out, some people say, I'm interested, and others say, well, no, maybe this isn't for me. And I think that's an important thing for you to do.
Well, if we could take a couple of minutes and focus on the different types of judgeships that are available. And in part, my question is prompted by several questions that have come in from the audience as to, are people that do corporate business transactional work at a disadvantage in pursuing a judgeship? Do you have any advice along those lines? And in that context, are there certain judgeships, whether it be bankruptcy court or business court judgeships, that someone with a business or transactional background might well have an advantage in pursuing a particular type of judgeship?
Chris, I'll take that. This is Judge Lynn. I think that if one has purely a business background, in terms of the federal system, which is all I'll speak to on this question, the bankruptcy court is probably the best realistic prospect. But even there, I think the bar, and I still remember what it was like to be a trial lawyer, and when I forget, my husband, who is one, reminds me. The bar wants people in court who have experience in court. They don't always get their wish, but I certainly have valued, and I think I can speak for Judge Davis and Judge Welch in saying that I certainly find my experience as a real trial lawyer valuable every day because I sometimes know what the lawyers are thinking, even though they don't sometimes want me to know. And so trial experience, I think, is the most valuable kind of experience to be a trial judge at any level. Now, there are many specialty courts where a specialty kind of law practice matters. The best example I can give is the Patent Trial and Appeal Board. One of my former law clerks was a patent trial lawyer and applied to be a patent judge and is a patent judge, and that's an appointed position. And she's a real judge. The only thing she doesn't have is a jury in the box. But that is the kind of judgeship where experience as a patent practitioner is invaluable. I know of many examples where prominent, well-regarded lawyers who have the kinds of experiences that Judge Davis and Judge Welch and I all mentioned have become trial judges. I remember in my new judge training, there were two incoming judges who really had never had experience trying lawsuits, and they had a very steep learning curve. Most of the rest of us were reading the sentencing guidelines and the rules of criminal procedure, and they were reading the rules of civil procedure and the rules of evidence because they really had not encountered those in their practice. But they were smart and great professionals and had to learn it, and they learned it, and both of them have the finest reputations that a judge could have. So it's certainly not impossible if you do the other things that we've mentioned, but I think it is harder to convince either the voting public or the appointing authorities that you should be a trial judge in particular if you didn't have trial experience. And for appellate judges, I've never been one, so I will let Judge Davis speak to that. But I think, again, if you don't have experience that is particularly relevant to the task, it's harder but not impossible.
Judge Davis, do you have any comments on the appellate bench, and to what extent is it crucial for someone to have tried cases to be an effective appellate judge?
That's a very good question, and one that one should think about very carefully. I have been a federal appellate judge now for about 7 years, and as you heard, I came to this position from the federal trial bench. There are, contrary to my experience, any number of federal appellate judges who come directly to the federal appellate bench without having been trial lawyers. Again, I go back to the lightning strike point. It's difficult to plan a career path that takes that trajectory. Many federal appellate judges, of course, are former law professors, and that's seen as something that generally qualifies one for the work of an appellate judge. But I suspect that most lawyers, and frankly many judges, both federal and state and trial and appellate judges, believe that it's good to have a healthy cohort of appellate judges who have in fact had a trial judge experience. Now, with regard to whether you can ascend the trial bench absolutely without any trial experience, I agree with Judge Lynn. I think that's a very, very tough climb. And certainly at the local level, and I think among the people who talk to United States senators with regard to the federal bench, they're going to be looking for people who have been in the courtroom, who understands what happens in a courtroom, and can show that they have a certain level of competence. Which is not to say, of course, that you have to have the entire breadth of experience that a generalist such as a federal trial judge is expected to have, or for that matter, a generalist that many state trial judges are expected to have. So many people who spend virtually their entire career as prosecutors successfully become trial judges hearing both civil cases and criminal cases. And likewise, many civil practitioners who have not had any experience on the criminal side do become very, very good and excellent trial judges in both civil and criminal cases. Just a quick anecdote, I will share with you that when I was appointed to the first judicial office that I held, which was on the lower state court here in Maryland, I was actually working and had been working for 3 full years as a full-time law professor. And I will tell you that that was very unusual, and that was 30 years ago, and there hasn't been another law professor appointed to the state bench since then. But what I had going for me in part was the fact that I had actually been a prosecutor, as well as certain other experience in the Department of Justice. So I had spent some time in courtrooms, and in fact what I was teaching was civil procedure. So there's no hard and fast rule about this. If there is one, though, I think it is the one that Judge Lynn alludes to, and that is that it's going to be very difficult to persuade appointing and electoral decision makers that if you haven't had any trial experience at all, that you should be appointed to the trial bench. And I suspect most lawyers wouldn't have that aspiration, but rather would be looking to possible appointment to an appellate court, which again, the breadth of experience that is needed at that level shouldn't disqualify really any practitioner.
We obviously have a number of folks on the line who are contemplating a career in the judiciary, and from my perspective, my understanding of what a judge does on a day in and day out basis changed dramatically from law school to clerking for a judge to seeing what it looks like actually inside a courthouse. And starting with Judge Welch, I was wondering if you could give us an idea of what it's like on a day-to-day basis and the sort of roles that a judge plays other than simply presiding over cases in the courtroom.
All right, thank you, Chris. So what you should know about me is I'm a state trial court judge in Indianapolis, which is the largest jurisdiction in our state. We have specialized assignments. I'm assigned to a civil courtroom, which means I have jurisdiction over all civil cases. I have a family law docket, and then I've also been appointed by our Supreme Court as one of the commercial court judges in the state of Indiana. So I preside over about 2,500 pending cases at any given time. I have 2 magistrates assigned to my court to assist me in handling these cases, and those folks are with me 3.5 days of the week. So on those days we run double dockets. Thankfully, when the Indiana Supreme Court started the commercial courts, they provided funding for me to hire a lawyer who is a full-time law clerk. Before that, in state court, we have much lesser resources, and so I did not have a full-time clerk. Now, the types of cases I handle, some very complex business cases. This morning, I was presiding over a wrongful death medical malpractice case that's set for a 2-week jury. Next week, I could be handling a family law issue, or Wednesday, I handled a car crash jury trial that we were able to complete in 1 day. So I have a real variety of case types, and so my days are not the same at all. Next week, I'm doing a 5-day bench trial on an annexation case, which is something I've never done after being a judge for 15 years, and I've really had to put a lot of time into learning the statutes and the law. So my day is very different. I may have a week after that where I have a week-long jury and it settles, and I'm doing lots of under advisements. I would tell you in my docket I get about 100 to 250 motions filed each day on cases. Some of them are complex, some of them are just simple enlargements of time. So I'm managing that. Now the other part of my job is my jurisdiction is 37 elected judges and about another 40 magistrates. And so all the judges have some administrative role on the court. I have several. One, I'm on the budget committee as we have to prepare a $57 million budget each year to our council. I do some work for the Supreme Court on a rules committee, and so there's lots of administrative roles that your Supreme Court may ask you to fill as a trial court judge, or that I have to do for my court. I then also have administrative duties within my court. So I supervise about, I think, 8 to 9 people. So I have to make sure that process is working well. We are moving to an electronic filing system. So you can imagine, since I'm in charge, I have to make sure the staff and I are getting that system down properly, and that we're ruling on motions in a timely fashion. So being a judge, I don't think, is just making decisions on cases and reading the law and writing opinions. You really have to be able to interact and manage people and manage the workflow that comes through a court that's real busy like this. So I hope that answers the question, Chris.
Thanks. And Chief Judge Lynn, my working assumption is that you also have a fair number of administrative duties as a Chief Judge. Could you also give us a sense as to what it is like to be a judge that someone wouldn't necessarily see from just being in your courtroom?
Well, of course, apart from my administrative responsibilities as the Chief Judge, which is to a large degree like the back office of an institution, you know, a lot of what we do is research and writing, and the three of us are bar junkies, and so we all run into each other all the time because we're the types of judges who can't say no, so we keep getting asked to give speeches and write papers and so forth, and so we all do that in different areas that we are interested in. I think that is a fun part of the work that we do to affiliate with the bar. I'll just take a moment of personal privilege to just reiterate what Chris said at the beginning. So Chris is the chair of the Lawyers Conference of the Judicial Division. People think that the Judicial Division is populated only by judges, but we actually have a number of lawyers who are supportive of the work of the judiciary, and we greatly appreciate that. So all three of the judges on the line have many occasions to mingle with members of the bar, and I think that is a fun part of our work, in addition to the fun part of our mingling that we always think is fun and the lawyers don't always think is fun, our encounters in the courtroom. But there's a lot of work that we do that is administrative in nature on an individual basis, and then as a court. In my case, because I am the chief, I have responsibilities, for example, over our probation office. That is a part of the Northern District of Texas, and I'm on an organizational chart. I have lead responsibilities for some aspects of that. So the kinds of things that you might expect the CEO of a small business to encounter, I might encounter in my role as the chief. Human resources issues, IT issues, building security issues, access for people who are impaired, all of those kinds of issues that those of you on the line who have occasion to do work with small businesses, your clients have those issues, and so do we. And even before I became the chief judge, we're all managers of some number of people, as Judge Welch mentioned, and so we have managerial responsibilities there. I hire law clerks, and so I go through the whole process of interviewing and mentoring my law clerks, and I think keeping up with them, that's growing my family every year, and I keep up with them and mentor them, and I hire interns. So there's a lot that we do that is behind the scenes that is an enjoyable part of our work.
Well, Judge Lynn, thank you so much for your point of personal privilege and your comments about the Lawyers Conference. And it's, I would certainly welcome 700 new members to the Lawyers Conference at the conclusion of this call. But it's really a pleasure to have the chance to help the judiciary and be involved in issues of significance. So what I hear our panel saying is that it's important to be involved in bar activities, the one's reputation as an attorney is crucial, and it does make a difference, particularly if you're seeking to run for or be appointed to a trial court, to have trial experience, perhaps less so for an appellate court, but it's certainly very helpful and valuable experience. What other overviews or takeaway would you really like for our audience to have that we haven't addressed so far with those three major points yet?
Chris, this is Judge Davis. If I could simply add briefly to Judge Welch and Judge Lynn has said about the non-adjudicatory kinds of responsibilities of judges, which are very important at all levels and all systems. I just want to remind everyone that we are, of course, bound by a code of judicial ethics. Judges have far more narrow First Amendment rights, as we all know, than ordinary people. But under the code, what's important to, I know all three of us, and I think all good judges, the codes, and there are differences between state codes and federal codes, but all of them contain a provision that makes clear that judges are allowed and indeed encouraged to engage in activities that broaden the understanding of the rule of law in our system. As we all know, what courts do is only accepted by the public by the integrity and impartiality that we bring to our work, and critical to that is also public awareness and knowledge of what courts do. And so giving speeches at schools and visiting schools, not just law schools, but elementary schools and high schools, and participating in those kinds of activities that broaden the awareness of the public at large about what courts do, how we do it, our commitment to transparency are all important parts of the judge's role. And I think that people who are electing and appointing judges bear those kinds of considerations in mind as well.
Well, needless to say, as we've been addressing some of these issues, we've had a number of questions brought up, and one of the topics that occurs most frequently throughout these questions is in connection with involvement in partisan politics and political activities, to the extent whether one is hoping to be involved in the federal bench, to be an appointment to state court or states that have elected judges. To what degree does it help, hurt? What advice do you give to someone as to involvement in politics, and whether that is a plus or a detriment to potentially obtaining a position in the judiciary?
So Chris, I'm happy to start. As a state judge, I've been elected twice in partisan elections. Our Court of Appeals and Supreme Court is a merit process with a judicial qualification committee, but as you might imagine, the governor in the history of the state of Indiana has never appointed someone who is not a member of his party. And then I'll let Judge Lynn and Judge Davis comment on the federal system because it is quite different. So for me, having been elected twice in a very partisan system, you have to be political. So many times I'll get lawyers that come to me and say, well, I'd like to be a judge on your court. Well, first of all, if you want to run, you have to determine if you're a Republican, a Democrat. You could be an independent, but there's never been one elected in this jurisdiction. It's difficult. You have to have a certain number of signatures to get your name on the ballot. So that requires really a three-pronged process. And one is you've been involved in your party at some point, because in our system you are permitted to raise money, and so you can't directly ask for the money. There are certain requirements under our judicial canons, that things that we can and cannot do. You certainly cannot directly ask for money, but you have the ability through a treasurer and campaign chairperson to fundraise. And so if you're not an incumbent, you really have to be able to have the ability to convince people involved in the party that you may be someone qualified. You have to go through a nominating convention. You would either be recommended by the party that you're a member of or not recommended. And you can still be on the ballot in the primary election. And that means if you're a recommended candidate, the party will stand behind you, and that means on election day when they pass out the election information, you'll be on that. If you're not a recommended candidate, then you have to do it all on your own. and then you'll go through the general election. So for a state trial judge in my county, you do have to be political, and that's the case in, I think, 88 counties. They are elected. In 5 counties, it's either a nonpartisan election or a merit process. Now, even though you don't go through it's a retention vote once you're selected to be on the Court of Appeals or Supreme Court, but you certainly have to have contacts, and I think the key there is that no governor has appointed someone to one of those benches that has not been of the same party that they are a member. So I will turn it over to Judge Lynn or Judge Davis for their comments.
Well, I have a unique situation here in Texas because we have Republican senators, have had, and for the foreseeable future will have, and during a Democratic administration, which there was one I was appointed, I was a President Clinton appointee, that required a blend of support from prominent Republicans and prominent Democrats in our state. Without that, one could not get through, and in fact, there were a number of unsuccessful efforts of the president to nominate someone who did not get through. So I was recommended at the instance of one of our congressmen, who is a Democrat from this area, who I had known professionally for many years, and he thought that I was moderate enough and well regarded enough that I could get through. And in fact, one of our senators at the time, Senator K. Bailey Hutchison, was a longtime friend of mine and was very supportive. But it was difficult to get through at the time that I did. I was recommended to the president in '98 and nominated at the end of '98 and confirmed at the end of '99. So very late in the administration. I was the last federal judge in Texas to be confirmed. So those were some stressful times and very difficult to maintain a practice as a trial lawyer, which I was while my nomination was pending. My actual and prospective clients were always asking me if I would be there to try their lawsuits. And the bubble above my head, which thank goodness they could not read, always said, "I hope not." But that wasn't a very productive way to get business, so those words did not come out of my mouth. But the long process, which obviously everyone is well aware of the long process today, I think if anything it's gotten worse, makes it very difficult for many practitioners, or I think it's a little less difficult for academics or those with state judgeships or magistrate judge positions, but it's very difficult for a person in private practice to continue with a successful practice while waiting for the time to pass, and that has caused a number of people to withdraw. So it's a challenging process in the federal system.
I can only add very briefly to what my colleagues have said by simply saying it is a political process, of course, as everyone on this webinar full well know. Whether you're in the state system with partisan elections or nonpartisan elections, and certainly in the federal system, the blue slip system, for which I'm sure many of you are aware. If you're not, just Google blue slip system. You'll understand what Judge Lynn was just describing. So it's something of a crapshoot in the federal system throughout the process. I will add briefly that historically, for appointment of federal trial judges in most jurisdictions, there was really a courtesy system whereby the senior senator of the president's party really got the last word on who would be recommended to the president and ultimately nominated to the Senate to take a position as a federal trial judge. In a lot of jurisdictions now, that historical system no longer obtains, and there are all kinds of merit selection boards, and in states where there's one Republican senator and one Democratic senator, they have all kinds of arrangements whereby they reach agreement as to how the recommendations to the president will take place. But there's no question it's a political system that you need to be aware of. I'll just close by mentioning how frustrated my wife is because she wants to use lawn signs and put bumper stickers on her car, but because I'm a judge and I sometimes drive that car, she's not allowed to do that. However, she is allowed, of course, she has her full First Amendment rights in terms of being able to give donations to parties and candidates of her choice, but I need to stay as far away from that, of course, as a federal judge as I can get. And
I'm sorry, excuse me, Andre. This is Judge Lynn. I'll just add one funny story that I think will demonstrate to everyone on the line how serious the last point that Judge Davis made is. Our good friend who is on the Third Circuit Court of Appeals, Judge Rendell, was married to the governor of Pennsylvania and was a judge on the Third Circuit. And she was prohibited from attending his fundraiser at her own house and had to leave her own home because despite the fact that he was her husband, we can have no involvement of any kind in any political matter. And so we just have to steer clear of it. Now, I will also say that in the state court here in Texas, where our judges run on a partisan basis, they are right in the thick of politics. And it is inevitable that they be. And they are required, because of the nature of the way the system works, to raise money, including raising money from lawyers and lawyers who appear before them. And most people are horrified by those facts. And so I will not get on my soapbox, but I think that those of you hearing me who were not otherwise familiar with that system would express concerns about what that system would look like to people from the outside, even though I have great respect for my state colleagues, and I think they do everything they can to eliminate any actual impropriety. I know they do, but it still is a system that makes those who are unfamiliar with it very queasy.
And let me chime in. Judge Lynn is absolutely right. So as a state trial court judge, most of us hate the fact that the system requires us to raise money. And in actuality, in my state, this system has been in place for many, many years, since the beginning of time of judges in our state. But last year, the Seventh Circuit declared it unconstitutional, not because we raised money, but for other reasons. And I think there might be some movement in some states for state trial court judges to not be elected for that very reason, because when you go through a merit process and you face retention, you can only raise money if you are specifically challenged. And so the rules for, I don't think, although I think the rules for federal judges are very restrictive, I have restrictions too. So unless I'm on the ballot, I cannot participate in politics. So I couldn't donate money to any candidates during this election cycle. I cannot appear at any events for candidates. I can support my party. I could show up to my party to help on voter registration, but I can't do anything that would publicly support any particular candidate.
Judge Lynn, I know that you're going to have to drop off shortly with a court engagement, and we will continue after you leave, but there is one point that I would like to get your thoughts on. We have been speaking about things that one can do to enhance their chance of being elected or appointed to a judgeship, but what are the things that one should avoid doing, particularly social media, things that you might do at an early stage of your career that could potentially come back to be detrimental down the road? Do you have any thoughts before you have to drop off?
Well, I might pass that one to Judge Welch for the moment, because she is the one who has to get off early. Not
oh, I'm sorry, Judge Lynn.
Okay, thank you, Judge Lynn. Well, I would tell you, so I am a judge. I do not use Facebook. I don't use social media. I simply have email and I have a cell phone. I am the mother of 2 teenagers who are 16 and 14, freshmen and junior, started school yesterday. So they have grown up with social media and can't believe it never existed. I chaired the Indiana Professionalism and Civility Committee, which was a committee established through the Supreme Court to educate the judges in our state on ethics. And in working with the lawyer who staffs the Judicial Qualifications Commission, I felt that being on social media would be too time-consuming and too challenging from an ethical standpoint. It is not prohibited, but the first dilemma that I considered was, well, I interact with hundreds of and even thousands of lawyers in a given year. Well, I would either have to friend all of them or none of them. Then what happens if I've got a pro se litigant and they try to communicate with me on Facebook about the case? I have to disclose that in my public file. So then I'm really managing Facebook from that standpoint too. The other issue that I think arises, and the example I'll give you is, so our court has about 40 magistrate judges, and it many times can be a pathway to become an elected judge. And through that process, I've had the opportunity to interview many candidates, and we were also interviewing yesterday and this morning for a director of finance position with our court. It is customary that we do the following. We do a check of all social media pages to ensure the things that you put on there are appropriate and wouldn't cause harm to us as judges or a court. We have a social media policy for our employees in the court. You certainly under no circumstances can ever discuss cases that have taken place in the courts if you work for a judge or in the administration process of a judge. And then sometimes we've seen Facebook pages where people maybe were not addressed very appropriately, or there were lots of alcohol in the photos. And so from a judge's standpoint, that can cause concern. So you, I think, have to be very selective if you want to use social media as to how you utilize it. I'm going to guess that Judge Davis and Judge Lynn, like I do when I interview for my clerk, we check those Facebook pages. I talk to them about my expectations and how they utilize it. And that certainly was a factor in me making a determination of hiring someone. So I think it is really critical how you use it on a personal basis. I think many folks who are lawyers, you have to utilize social media in some fashion as a business tool, but you just have to make sure you're professional about it and you don't misuse it.
Thank you, Judge Lynn and Judge Davis.
Yeah, I will just address briefly the Facebook question. I'm instructing all of you on the line not to friend me on Facebook, but I am on Facebook, and that's so that I can see pictures of my grandchildren and send them to my friends. I will tell you that being mindful of the issues that Judge Welch mentioned, I remember one time I read an article. I just read it, and somehow it got posted on my messenger. And one of my former law clerks wrote me a message that said, "Oh, Judge, I guess they've changed those rules about you being involved in politics." And I was just horrified. And it was up there for about 15 seconds, but it emphasized how careful one has to be. It's fraught with danger, but it's the way I get to see my grandchildren, so I have decided that I will be very alert and aware, but not take myself off of it.
I would simply add by stating the obvious to all, your integrity is the coin of the realm, so don't be a jerk. Achieve excellence in all of your work as a lawyer. You want to be the kind of lawyer when you walk into the courtroom, the judge looks up and says, "Oh, I'm so glad he or she is here," because she gives it to me straight. She's always excellent. She's always prepared. She's always courteous. She's always professional. She shakes hands with the lawyers on the other side. She doesn't get involved in some of these terrible discovery disputes. That's the kind of professional reputation that you want to develop. And anything you do that could undermine that effort will come back to haunt you when you seek a judgeship.
Well, and I'll also add that everybody needs to know that judges talk all the time about lawyers who appear before them, both because they've had a wonderful experience and because they've had a horrible experience. And so if the three of us were on the same court and a lawyer was outstanding, we would hear about it. And if a lawyer was lacking in the good qualities that Judge Davis just cataloged, we would know about that too. And so when one steps over the line, it takes many years, if ever, that one can pull that back, because I think the coin of the realm is the perfect phrase. It really matters. It matters for your being considered for a bench, but it also matters for the success and happiness of your career.
Well, let me take one of the other audience questions and put it out for our panel. What made you become a judge? What motivated you to pursue a career in the judiciary?
Gee, I guess I'll take that one first. I came out of law school and was fortunate to have two clerkships, one a federal district court clerkship and one a federal appellate clerkship, and went into the Justice Department at the conclusion of that second clerkship. And my aspiration absolutely was to be the best lawyer I could possibly be. And I will tell you that having worked for two fantastic judges whose commitment to the rule of law and to equal protection under the law and to substantial justice was second to none, I absolutely did not want to be a judge, because I understood what it required of a person, the hard work, the difficult decisions, and so on. And so something happened in the ensuing 5 or 6 years, and I think it mainly was my law teaching that prompted me actually to change that attitude and to think, and I would like to think it was done very humbly on my part, that I could perhaps live up to the standard that these two extraordinary judges that I had the great privilege to work for, that I could somehow meet that standard. So I kind of threw my hat in the ring. As I mentioned earlier, I was a law professor, and law professors don't get appointed to the state court in Maryland, but I thought I could do the job, and I thought I was qualified, and I sort of took a chance, and I had some great people supporting my application, and the governor saw fit to make the appointment, and I haven't looked back since. It's been a wonderful career for me, and it's so great when you end up in a position that you love, and really I would do it for free if I had another way to make a living.
So this is Judge Lynn. I was interested in pursuing the position early on in President Clinton's term, and was not successful in becoming the nominee. Went back to being a great lawyer, and I hope I was a great lawyer. That was my aspiration. And then the call came unexpectedly to me about 5 years later, asking me to allow myself to be nominated. And I had to think hard about it because I loved being a lawyer. But I decided to go for it because of the public service aspect of the job, and hoped I could be good at it, and had a husband who could support the fact that I was taking a big pay cut to do it. So that's how I got there.
Well, one of the other audience questions before we move on from the questions that have come in is, for someone who is deciding, who knows they want to be a judge, coming out of law school, do they have more of an advantage to pursue a position as a prosecutor or a public defender? Is there any difference between the two in terms of likelihood of enhancing your chances of being on the bench?
Well, go ahead, Judge Lynn.
Oh, it's Judge Welch, Judge Davis. Well, I would say in my jurisdiction, in Marion County and the state of Indiana, many times a common pathway is you've been the elected prosecutor or a prosecutor in the office of deputy, and you become a judge. But I don't necessarily, we have a dedicated public defender agency, and so there are a number of people that have gone through that process too. So I can't say that because you're a prosecutor or a public defender that you have an advantage. I think it probably depends on the system where you are as to where, what your likelihood of ascending to the bench may be.
Just hearing the three of you talk, there are certainly many very important takeaways from all this, but I get the sense that what really resonates most is the emphasis on professionalism, being out, serving the bar and the community, and doing your absolute best as an attorney, and that is perhaps the best way to increase your chances of one day being on the bench. Have I oversimplified things, or are there different perspectives as to what's the most important takeaway for our audience?
Well, this is Judge Lynn, I'll only add that I think there are probably more prosecutors who are federal judges than there are public defenders. I know of public defenders, but I think I know many more who have been prosecutors. I just think that that is consistent with what many people think is the background that is more helpful to being a judge. I don't share that view personally, but I'm not the one making decisions about who becomes a judge. So if one were making a decision purely based on what made that more likely, I think a prosecutor position would have a greater statistical likelihood, but I don't think that's why someone should pick one or the other. I think they should pick it based on what they most want to do and let the chips fall where they may. As I said, you come back to lightning striking, you don't want to do too much to base your career on the prospects of something that is remote anyway.
Any takeaways before we wrap up this hour chatting with folks on the line?
I would say work hard, don't be a jerk, and good luck.
I'll ditto that.
Same here.
Well, let me just thank everyone for being on the line, and thank you so much, Judges Davis, Lynn, and Welch. I certainly have felt like this has been a great insight to the judiciary and how the three of you came on the bench, and very much appreciate you sharing that with folks. I would encourage everyone on the line to continue to take a look and take advantage of the Legal Career Central website. If you have an interest in additional information concerning the Judicial Division, please don't hesitate to read more about the Judicial Division and reach out to any of the chairs of the various conferences within the Judicial Division. We'll remind people that of the upcoming Legal Career Central on September 9th and October 14th. And would also like to remind people to complete the survey at the end of this presentation, and let me just finally say that it is truly an honor and a privilege to be moderating this discussion with three absolutely outstanding jurists. It is a privilege, and I want to thank everyone on the line and hope that everyone has a great day. Take care and have a great afternoon.